Good morning to all of you, my dear friends. Today we shall discuss regarding the 8 points of the Supreme Court, which is given by the civil case number 990 by 2021, and that 8 points also one of the somewhat of disclosure and all the public authority across the nation they should disclose. So it has instructed by the Honorable Supreme Court of India. So before this, I may request all of you, please visit, watch this video starting to end, and please do like, share, and subscribe because your all the subscribes is giving us inspiration in order to prepare new video and present before you. Thank you so much. Then we shall start today the 8 points of the Supreme Court by civil case number 990 by 2021. What says the 8 points? So one by one we shall discuss. The first point, the 8 points of the Supreme Court's information is the first and foremost point is that is transfer policy and transfer order. What is the meaning of transfer policy and transfer order? That is the meaning means that is the transfer policy and transfer order. It emphasizes or it cites or it says that is posting of government employees, rotation, transfer policy and CSS etc. Means that is when an employee of a public authority, he is transferring from one public authority to another public authority, the name should be reflected and the order or the circular or the notice by which he has been transferred from this A department to B department, that order should be hyperlinked there. So this information should be given all the public authority because all the public authority has the information regarding this, the transfer, how they are transferring. One employee is transferring means basing on the circular or basing on the order copy of the office or order notice of the office. That's why what is the order copy, what is the notice, what is the guideline or what is the instruction has been given for the transfer of A from B to C. Likewise, we have to give here what is the transfer policy and transfer order. Of course, it is prepared by the administrative department since in each and every public authority, some employee they are transferring basing on some circular or order copy or notice that we have to mention here for the financial year. This is the first point. Then second point, that is procurement. In every and each public authority, they are purchasing. For example, we may say, what is the procurement? Procurement means that is the process of purchasing goods and services for our public authority. For your public authority, what is necessary for stationery saman, pen, pencil, or whatever may be your white papers, xerox paper, or whatever may be chair, table, or whatever may be Godrej, whatever may be. The stationery goods or materials we are purchasing on which basis? Tender basis or GM portal? In which basis we are purchasing or in which basis we are disposing the old thing or distracted thing or unused things. This matter should be, we have to reflect it under this procurement policy. This is the second point of Supreme Court of India. Then third point says that is public-private partnership. What is the meaning of public-private partnership? Meaning of public-private partnership is that public-private partnership involves a collaboration between a government agency and a private sector company that can be used to finance, build, and operate. If we have some institution or organizations or company in order to implement our scheme, in order to implement our activities for the benefit of the public employee, benefit of the public authority, benefit of the public domain. So if you have some body or some institution or some organization, then what is the status of the organizations? What is the base route of the organizations? What is the features of the organizations? Which one the organizations we are, and with him or with that organization or institution, we are doing collaboratively the activities of the government. That thing should be reflected. If we don't have, then we may write here not applicable for this public authority. If you have, you may write it. This is the clarification of your public-private partnership. Then point number 4 says that is RTE application. Very important for each and every public authority. Department to Gram Panchayat. This is related. Every public authority should give this information. What is that? For example, RT stands for the right to information. It is a fundamental right of Indian citizen to seek information from the government offices, departments, ministries, and all the organizations run by the government of India or any other organization substantially aided by the government of India or any other government of state. So in this case, how much application the public authority or public information officer has received during this financial year, and out of that, how much he has supplied, out of that, how much he has transferred, out of that, how much he has rejected. This information should be reflected in this RTA application. Point number 4. This is very clearly, it is relating to all the public authority from department to Gram Panchayat, all the public authority across the state. Every public authority has this information. Every public authority should be reflected this information. Right? This is the point number 4. Then point number 5 says that is CH and PSC paras. Of course, some offices for some offices it is not related. To whom it is related, they should give the information. What shall be given the information? It is basically purely says that is Ministry of Electronics and Information Technology, Government of India or Government of Odisha. Whatever the paras has been given by us to the authority, and whether it is pending or whether it is outstanding, that information or that status should be given in this point number 5. If it is related to our public authority, if it is not related, then we may say that is information is not related to us or not applicable for this public authority. These things we have to write. This is for your clarification I am giving. Then point number 6 says that is citizen charter. Citizen charter is the purely public document. Meaning of citizen charter is a document of commitments made by government organizations to the citizen, maybe client, group in respect of the services, schemes being provided. What is the commitment has been given by the government for the citizen, for the public or client or the groups? If that's such type of information we have, the public document, every much more public authority, maximum public authority, they acquire this public document, because in a institution, in a organizations, in a office, in a public authority, there should be a public document, and that public document should be reflected under this point number 6, that is the citizen charter. Then come to the next point, that is point number 7, that is discretionary and non-discretionary grants. First of all, we shall discuss what is discretionary grants. Discretionary grants are the grants given by the center and the state for public purposes. The grants which have been given by center may be center or may be state for the public purposes only, even if they are not within their legislative competence. Even if they are not within their legislative competence. So if we have received some schemes or financial benefits or financial schemes or contribution by center or the state, that we may cite here. But we have to keep here the manual number 11, it is not included here. Out of that, manual number 11, budget allocation to each agency, that is the one point of the summatory disclosure, one point or one manual of the summatory disclosure or proactive disclosure. But here it is clearly said that if you are getting some financial contribution or some grants, especially some grants by center or the state, and it should be used only for the public, then we may cite here, even if they are not within their legislative competence. This is the discretionary grants. Then non-discretionary grants says that is, what is that non-discretionary grants? The non-discretionary grants says that is the meaning of non-discretionary grants is no discretionary grants means Meaning of non-discretionary grants means a grant in which the recipient of the grant fund or the formula for the grants award is specifically stated in the legislation, authorization, the grant, or in specific agency regulations promulgated by the agency and reviewed by the Arkansas legislative councils. What is the meaning of Arkansas legislative councils? The Arkansas legislative councils means it is one of the most powerful and influential committee of the Arkansas General Assembly. If such type of information we have, then we may reflect here. If we don't have such type of information, then we may say that is not applicable in this public authority. We may write here. Then next point and last point of this 8 point, that is the point number 8, that is foreign tours of the chief minister and other state minister on summary disclosure. Authorities, this means authority may proactively disclose the details of the foreign and domestic official tour. Or if you have the information regarding the foreign and domestic tours regarding on summary disclosure, if you have the information, then you may reflect here. Otherwise, it is not relating to another any public authority. It may be relating to the Department of Parliament Affairs Department, because they may deal with these things. They may give another public authority, they may not have this information. So in these cases, other public authority, they may write this information is not applicable for this public authority. So already I have discussed with you the 8 points of the Supreme Court, which is given by Honorable Supreme Court of India, by civil case number 990 by 2021. So I hope you have watched this video, and I may request all of you, please do like, share, and subscribe. Thank you so much. Bye bye. Namaskar.